Welcome all to the Global Antitrust Institute 7th Invitational Moot Court Finals, which we'll be hearing at noon Eastern U.S. time, about 20-some minutes from now. I'm pleased to introduce the panel for this final round. Judge Ian Forrester, until recently a judge of the General Court of the European Union, and our lay judge, Timothy Muris, the expert member of the panel and former chairman of the United States Federal Trade Commission. So we have some time now before the arguments begin when we thought we would discuss the case a bit and explain to you all a little bit of the setting. The competitors have been given a set of facts, and they have argued on either side of the legal issues arising from those facts. Each team has argued previously 4 times. Each team has argued on both sides of the issues. This forum is the mythical Masonia Supreme Court. Masonia is a new jurisdiction. It does not have a body of competition law, but it is authorized by the legislature to draw upon the best or most persuasive authority from anywhere in the world in resolving a competition dispute such as this. The parties have made some important stipulations, so they won't be discussing or spending time on those few points. In particular, they have stipulated as to the definition of the market. The market here is the global market for online news content creation and distribution. Secondly, the Apple News Network market share information has been stipulated. When the platform was launched, in the first year they had a 37% share of that market. It was 39.5% the following year. By the end of the second year of operations, it was 42%. That's when the facts giving rise to this dispute arose. When Apple News Network terminated the participation of the New York Times. Nonetheless, it is projected by market analysts that the Apple News Network platform share will rise yet again in the third year without the participation of the New York Times to something between 49 and 52% of the defined market. I think that's all you need to know by way of the stipulations, but I think it's an opportunity now for the 3 of us as judges to talk a little bit about the problem and some of the difficulties created by all law being relevant here, principally, of course, that of the European Union, which is followed in so many other jurisdictions, and that of the United States, and other jurisdictions that may be brought to bear by the advocates. So, under Judge Forrester, if you found it particularly challenging to grapple with the application of an unknown or unlimited body of law?
Well, when you arrive in Luxembourg as a judge, you're expected to be, I won't say expert, but at least competent to decide cases about trademarks, access to public documents, public access to secret documents, plant varieties, or public procurement. And in my time in the court, I think I had only 4 or 5 antitrust cases, and 2 of those, to my great regret, because I was really enjoying getting ready to make some law, got settled, and so they shot the fox. I found this very interesting because it presents questions which have arisen before the European Commission, before the courts here, after my time, after I went to the court. So I'm less informed than I should be about some of these questions, and it's been nice to acquaint myself with them again.
Oh, good. I thought it was particularly accidentally timely to be discussing this defined market here in light of the events of the last few weeks involving Australia and both Facebook and Google and the way in which they relate to content providers, news content providers. Tim, or for today, Judge Muris.
Can't hear you.
Ginsburg. Well, I'm thinking how to phrase this question. The side, the plaintiff, whatever we call them, they're going to want to use European law. The other side's going to want to use American law. The questions are, I mean, a logical question is going to be, to one side, what's wrong with the other side's law? I obviously that's legitimate, but that turns into a fairly high level philosophical kind of question. I don't know, and I mean that's perfectly fine, but I don't know, Doug, if you've been involved in prior rounds. I mean, obviously the whole thing could get tied up around that.
I have not seen the prior arguments. No, I've come here as a virgin now, just like you.
Yeah.
So
well,
it could do, but I think we have to move them along and say, well, let's assume something, whatever it is that will take us to the next point in contention.
Sure. Well, look, no, that's an interesting question to me. What the Europeans, ones like the Europeans, are going to ask, are going to be pushing essential facilities, and a question I want to ask them is, Phil Arito, Professor Arito is one of the most famous American scholars, and one of his most famous articles was called "Essential Facilities: An Epithet in Search of Leading Principles." He didn't think much of the doctrine and
Yes.
why.
Sure. And
yeah, go ahead. I'm sorry.
No, sorry. I'm just saying, yes, I agree. I am not convinced that essential facilities is part of European law. There is no judgment that endorses, I think there's no judgment that endorses that proposition specifically. It's invoked very, very frequently, and maybe I've invoked it, but I don't think that there is a judgment where the Court of Justice says it's part of European law. There is a stronger European moral element. That's true. So Europeans don't like it when the elephant squishes the monkey. But essential facilities, I don't think as such is part of European law. I'm sympathetic to the notion that it ought to be, but I don't think we've got there yet. And is anyone listening to us? It's just the three of us.
No, we have an audience.
Sorry?
We do have an audience.
Okay, right. But not the advocates.
Correct.
Okay.
But that really narrows the gap appreciably, because by the same token, the Supreme Court here has neither applied nor repudiated the doctrine. And in the last case raising it was explicit about that. And it is open to, in the United States, it's open to a court of appeals to adopt and apply the doctrine and see what happens if it gets to the Supreme Court.
Yes.
And of course, we here in Masonia are even further at large.
Yes. Although it would be a brave court indeed to adopt the doctrine, I suspect, as long as people like Steve Breyer are around.
Yes, well, that could change.
That's true.
Steve has been a force for level-headedness for his entire career in antitrust and on the courts.
Yeah. As I said yesterday in my session, that Ralph Nader and Lloyd Constantine opposed his confirmation on the basis of his what they regarded as his aberrant antitrust views. So.
Well,
I was told that when my nomination became public on the occasion at the same time as an ICN meeting, and someone at the ICN said to the European Commissioner, "We express our profound sympathy."
well, of the two cases in which you did participate, did the commission fare well?
Let me think. One of them, it was challenge to a refusal of a complaint, and we agreed with the commission. And one of them was about, it's scarcely a competition case, it's about excessive delay in the handling of appeals. And we crafted a financial compensation remedy, which I fear did not entirely make the cut in the court above. So I don't have a particularly glorious competition law record.
Well, you did as you went to the court before getting there. So aside from the essential facilities gap that you identified, Chairman, that may prove to be narrower than you thought, is there another disjunction like that you think will plague us?
Well, certainly the sympathy in Europe, and I'm hardly an expert, and what I know comes more out of DG Comp than the courts. The sympathy in this set of facts for the way the New York Times was treated, even though it's it's a big boy and can arguably take care of itself, even in United States law, because you had a prior course of dealing. But in European law, which is more competitor oriented, that's a real difference, I think. It's certainly a difference in the way they, in the way they acted in DG Comp.
Yes.
Mm-hmm.
Yeah. The moral rightness of the complainant is a big driving factor in the carrying through of cases, at least in my day, I think. I'm sure.
I think that is what the ECJ pushes against when it encourages more reliance on economic evidence and theory, as in the Intel case most recently, and before that, carte bancaire. In each case, I think pushing the commission toward a more rigorous set of tools. I was amused in the Intel case, of course, these decisions are so long, so many hundreds of paragraphs, it's possible to find many things, including some contradictions. But there's one lovely one in which one paragraph, the ECJ says something that our courts say all the time. The mission of the competition law is to preserve competition, not to preserve competitors. And then about two paragraphs later, but of course, without competitors, there wouldn't be any competition. So evincing a certain sympathy for preserving them. But the end result was, I thought, a good move, a very good move.
Oh, yes. I mean, European law is unique in having this preoccupation with the creation of the internal market. And in our young day, parallel trade cases, people hindering the mass export of goods by so-called grey marketeers from France to Germany where the price was higher. That was the most terrible crime. That's a European first. And it has not disappeared from the European enforcement agenda, but it's definitely much less important. And now,
because of success.
Well, because of its success, yes, sure.
The single market is a reality, and then exceptions arise. Now, I think there's an interesting example. It might come up today because of some brand image discussion in the bench brief, but in the Cody Germany decision, it's quite interesting. I thought we're now talking about balkanization not by geography but by different media of distribution, and company trying to control the way in which its product is sold on the internet, or to preserve a brand image. I think that's going to put the vertical block exemptions and the whole review of the vertical block exemptions into a difficult spot.
Yes.
I mean, that's a very difficult line to maintain.
Yeah.
Luxury goods. And indeed, the luxury goods moniker has been applied in the member state courts to a variety of things that might be surprising, not always successfully, therefore not always to the vindication of the brand, but
yes.
Things like steel, STIHL, steel chainsaws and garden tools and things like that.
Coffee cups and saucers.
There you go. All right. So I think that very much like our Sylvania case, once the court, looking at a vertical case, said, well, this is non-price restraint and it's okay, and held out for 40 years until it abolished per se treatment of minimum resale price measurements. Once the principle is breached, it's just a matter of time.
I was doing a seminar this afternoon for a Glasgow law school, and I was teaching about the evolution of compulsory licensing. And you start with Volvo Veng, where the court says, well, normally it's okay for a license, for a right holder to refuse to grant a license. That's part of the intrinsic rights. However, and everyone gave a big sigh of relief. And then a couple of years, 4 years later, it was McGill, where a compulsory license was okay to remedy a bizarre situation. And then there was IMS, and then there was Microsoft, which says you can compel a license to deliver the capacity to build a copy of the target company's product, which was patented and copyright and trade secreted. So yeah, plant a mustard seed, and 20 years later you may have an oak or a monster.
Well, one inhibition that's been erected is in the Huawei against ZTE case on the licensing of standard essential patents, where the European Court of Justice prescribed a procedural sequence of four
yes.
things that have to happen before the patentee could get an injunction. But it's easy to follow those steps. I mean, it was, in my view, there should not be any inhibition about the ability to apply for an injunction. But if you're going to have any, these were the most sensible ones you could imagine. It was a very interesting result coming from the ECJ.
Yes.
I think we had better sign off for the public viewing now, suit up, and come back. We have 7 minutes before we go live with the competitors. Welcome to the Supreme Court of Masonia. I'm Judge Douglas Ginsburg. I'm joined today by Judge Ian Forrester, until recently a judge of the General Court of the European Union, and by our lay expert judge, Timothy Muris, former chairman of the United States Federal Trade Commission. I understand that the plaintiffs here will be dividing their time and reserving 2 minutes for rebuttal. Is that correct?
It is.
Counsel, you may proceed.
Mr. Chief Justice, and may it please the court. My name is Ezra Louvis, representing the plaintiff, New York Times. This case is about the rules of the game. The game is competition, and Apple broke the rules by acting as both a player and a referee in the global market for news content creation and distribution. This court should find Apple liable for two distinct antitrust violations. First, I'll discuss why Apple has market power in the relevant market and discuss the refusal to deal issue. My co-counsel will talk about competitive issues related to the design of the Apple News platform and its rules of behavior. First, Apple has market power in the relevant market. The parties have stipulated that in a year, Apple's market share will be 49 to 52% of the global market. Under the EU case law in OXO, 50% market share is enough to presume market power without anything more.
Well,
what's the
prediction, isn't it? This is a prediction, not even where we are, correct?
Judge Ginsburg, that's absolutely right. But competition authorities, both in the US and the European Union, consider future increases in market share. And courts do as well, especially when the parties stipulate to that as an economic fact. Now,
okay, fair enough. But what happens if the next biggest company has a 40% market share, or if the next biggest company has a 10% market share? Doesn't that alter the confidence with which you can advance the contention that Apple's dominant, that there's dominance?
Judge Forrester, that definitely would alter the contention if we're looking at features of the market. And I'm happy to talk about that because what we have here is very different from that condition. We actually have two features of the market that cement Apple's dominance, one of which is a barrier to entry, the other is an economy of scope. The reason Apple was able to enter the market and immediately attain 37% market share is that it has an efficiency from producing both Apple News content and from producing iPhones. Its position as an original equipment manufacturer allows it to reach hundreds of millions of consumers immediately without the costs that a traditional news company would.
That's a bad thing?
Your Honor, that's not necessarily a bad thing, but it is a reason why other news companies in the global news market would have a much harder time entering the market and competing with Apple. And it is a reason here why Apple, given their dominant position, why their special responsibility is especially important.
Well,
Now,
it's a little peculiar to hear you talking about a barrier to entry on behalf of a company that undertook to enter.
Your Honor, I want to make an important distinction there, which is that the New York Times has not yet actually entered the market. What this case arises out of is conduct that occurred just after the New York Times announced that it would try to enter the market, which is why this is particularly concerning, because it looks like Apple is attempting to act like a gatekeeper for this market and to prevent future competition, as in a case like Lorraine Journal, rather than to aggressively compete on the merits.
So if you don't have the advantage, as I guess you don't, of being built into the operating system of hundreds of millions of units around the world, how would the New York Times propose to distribute its access to its competing service?
Well, Judge Ginsburg, it would still be able to use its app, which consumers are freely able to download from the App Store or in the relevant analog to that on a number of other different devices. What we're concerned with is just being able to compete on an equal playing field. As the general court recognized in Microsoft, the New York Times doesn't have a right to the exact same product as Apple. We do have a right to attempt to compete on an equal footing, which is all that we're asking about.
Well, in the Microsoft case, the second best form of distribution at the time was sending out free disks on a random basis to resident addresses. It was so far inferior because they'd been excluded from distribution over the Windows operating system. I don't see that the disadvantage is very significant here. You just have to download an app, the consumer would, right?
Judge Ginsburg, I think the disadvantage is actually quite significant. And this takes me to the refusal to deal. And the first aspect of that which addresses your question, is the refusal to provide access. So this is Apple's denial of access to its proprietary data, which we think is sort of like refusal to supply cases or an essential facility case. And that's especially important here because it's important for Apple, for the New York Times to even be able to do its business and to compete as a platform. Apple is able to gather years worth of data from a number of different streams based on content creators that are on its application, which allows it to produce targeted news.
How long have they had outside providers of news on their platform?
Judge Ginsburg, they've had that for 3 years. And what's important is that they've had access to a number of different streams of data for all 3 years. And that data is not, it's not like wealth. It's not something that you can just bank and use for a time. It goes out of date very quickly. So, for example, the data we're getting right now probably has a lot to do with what's going on in Texas. It might still have to do with impeachment or the Super Bowl. That data will become irrelevant very quickly. And so continuing access to that stream of data is what's so important. And there have been a number of cases, the IMS health case in the European Court of Justice, the Microsoft case, and even in the US, the FTC has recognized that data can be essential to competing effectively on a market and effectively bringing a product to market. Now, something I think Apple will likely raise here is that we might be asking for access to its intellectual property. And I want to note an important distinction. The premise of the Apple News platform is reciprocal. The only reason it works, the only reason why Apple News Network is effective and targeted is because creators like the New York Times share their data. So this is not a situation, even like Microsoft or IMS Health, where we're actually asking for intellectual property. We're merely asking for the same data that Apple gets from everyone else on the platform that it has dealt to us for a number of years. And so
they aggregate. Go ahead, Judge Forrester.
Okay. IMS is a case which I argued and in my days at the bar. Now, my recollection is that the Court of Justice produced a judgment saying a compulsory license, that's to say a compulsory access to the IP, to the raw material, would be acceptable only where it's absolutely indispensable and in order to produce a new product, something that is quite different. I don't feel comfortable with your invoking IMS in your particular circumstances. Tell me why I'm wrong.
Judge Forrester, for 2 reasons. The first is this is a much easier case to decide than IMS because we're not asking for intellectual property. The data at issue there was a proprietary way of analyzing pharmaceutical information. Here, that's not the case. It's simply a data set that Apple collects from news providers on the platform that they agree to give to Apple. This is not something that Apple produces internally itself with its own systems.
But it creates, from this aggregation, it creates something to which you want access that is itself their intellectual property.
Judge Ginsburg, I think that's correct. The distinction, though, is that it's not the same sort of self-created data or technology that was at issue in these cases. And the second reason I think this is distinct, or why you should feel comfortable with it, is that the New York Times is not effectively able to bring its product to market without this data. Because if we try to bring New York Times 2.0 forward, it will never be as targeted. It will always be behind Apple. And because we don't have that well of data to begin with, it will be very hard to attract other content creators to our platform as well.
When Apple launched not long ago, they didn't have anything. Right? There was no experience. They simply began the offering and data came in.
Judge Ginsburg, that's exactly right. Now, the thing that's different about this is that Apple did have that particular advantage, the economy of scope, which allowed them to do this much more efficiently than even a traditional news company.
Let me ask a question. Your introductory remarks made a comment about Apple's having dual roles here, and the comment sounded pejorative to me. Did I take that correctly?
You did, Your Honor.
So what was the point of the comment?
Your Honor, the point of the comment takes me to the termination of the relationship with the New York Times, which is that we essentially believe that Apple is acting as a gatekeeper and attempting to exclude the New York Times from the market. Now, when you analyze a termination of a relationship, this is under the Aspen line of cases in the United States, you look for two things. You look for a prior profitable course of dealing and a willingness to forego short-term profits for an anti-competitive end. What we also have here is an email directly from the CEO of Apple, which essentially directed them to undertake exclusive conduct. Now, that's not an element of any of the theories, but courts ever since Alcoa have recognized that is probative of the sorts of justifications a company uses for its business activity. Now, this email was entitled Operation Blindfold, and Tim Cook directed the head of Apple News to find him a reason to kick New York Times, who he referred to as punks, off of his platform.
Well, if there were in fact reasons, then it doesn't matter that he solicited.
Judge Ginsburg, you're right about that. And this goes to the distinction between whether this is actually aggressive competition or exclusion. And we think it's exclusion for the following reasons. The best argument that Apple can come up with is likely that the termination of the relationship placed Apple News in a better competitive position and would have made it profits. The problem with that argument is that Apple lost money after terminating the New York Times. It lost the shared ad revenue. We have no evidence in the record that indicates it replaced that revenue with anything, and it probably also lost subscribers. The only way that terminating the relationship could advantage Apple is if it enabled it to harm the New York Times. Therefore,
if there were violations, then it simply had a right to vindicate its rules and deter others from violating them.
Judge Ginsburg, that might be a justification if Apple actually followed through on its policy, which it didn't. Apple didn't even apply its policy as written. The data policy, for example, says that you need to have 3 violations before you terminate access to its data. Here, there was only 1, which is especially suspect. You would think that if Apple was actually interested in terminating its relationship, it would at least follow through with these policies. This is especially concerning because it undertook this conduct.
Fair enough. You've got what might well be persuasive arguments about contract breach, but are they in an antitrust case? Do we need to police these questions?
Judge Forrester, you're right. This is not a breach of contract case. Your concern is about harm to consumers and harm to competition. And we think the termination of the relationship did both. It resulted in a situation where consumers, at least consumers on the Apple News platform, were getting less for the same amount of money or more because they had less access to the news services on the platform. It also harmed competition because, as I referred to earlier, Apple was denied access, or the New York Times was denied access to data that's essential for it to produce similarly targeted information. And that gets...
Let me go back on that again. The Apple started this without data. They just went out there and did it. And I'm not understanding why it is somehow a barrier now for someone else to go out and do that, especially a prominent element in the world of news gathering and dissemination. I mean, there are any number of companies out there, the Globe and Mail, News Corp, just in the English-speaking world, that could do the exact same thing.
Judge Ginsburg, the reason for that is that Apple attained that data at no cost. They entered the market immediately. There were no other competing services, and companies simply bought access to the platform.
Well, actually, you present that as if it was their fault.
Judge Forrester, I don't think it's their fault. What is their fault is exclusionary conduct they might take afterwards. I see my time has expired. Can I conclude briefly?
One sentence, please.
Yes, and for that reason, that exclusionary conduct is why you should find them liable. Thank you.
Thank you, Mr. Louvis.
Mr. Chief Justice, and may it please the court. I'm Nick Fordice for the plaintiff, New York Times, and I will be expanding upon my co-counsel's argument to illustrate that Apple, at the design of the Apple News platform, incorporates an anti-competitive self-preferencing scheme, and that the rules of behavior imposed on competing legacy providers were meant to design a self-benefiting field of competition. Before proceeding to the merits, as a preliminary matter, it's important to note that these abuses are colored by the special responsibility a dominant firm takes on to refrain from weaponizing its dominance to distort competition in the marketplace. As the European Court of Justice noted in Deutsche Telekom and other cases, a dominant firm has an obligation to maintain an equality of opportunity for its competitors in the marketplace. This concept is mirrored in the understanding in US antitrust law that certain businesses practices permitted of a smaller firm become anti-competitive when exercised by a monopolist. In this case, as my co-counsel identified, Apple wears the hat of both referee and player in the global internet news market. Apple took advantage of this dual position to design a self-benefiting field of competition on the Apple News platform. On to the merits.
It would be peculiar if it weren't self-benefiting, wouldn't it?
Well, Your Honor, it is true that a firm has, even a monopolist has a prerogative to turn a profit and find a way to run its business profitably. But when a firm becomes dominant, it must refrain from using that dominance to exclude competition on merits other than the product itself. And we can see
a situation where they created a new product, a new thing in the world just a few years ago. And you're saying that was a detriment in some way to consumers, to I don't know what.
Well, Your Honor, no, the problem arises in that there are two products in this case. Apple News, the platform, and A&N, the content producer. Apple is using the innovative power of the Apple News platform to shore up the market position for A&N, the content producer, and garnering market share for A&N on a basis other than the merits of A&N as an independent product. This violates the basic antitrust principle we can observe in Berkey Photo and in the EU in the Google search shopping case, that a firm can't use the attractiveness of one product to leverage into market position with another product.
Now, I take it from your colleague's argument that the way in which it did this, to the extent of occupying about 80% of the so-called front page, was by using the data and analyzing the data that it had acquired in order to target things to people who would find them interesting.
Well, Your Honor, first I'd like to point out that the argument that this is based solely on consumer demand, that this is driven totally by the data, is specious, in fact, in light of the fact that it is such an even 80-20 split over time. We can use circumstantial evidence to determine that this algorithm is operating on some sort of more arbitrary level, in that a nascent news provider manages to occupy such a commanding majority of the front page religiously at a regular rate. This is similar to the circumstantial evidence the European Commission on Competition looked to in the Google search shopping case, where it found that the fact that Google products were appearing in the top search results 60 to 80% of the time ahead of competing services that were more relevant to consumer searches led the commission to the conclusion that Google was self-preferencing in some non-meritocratic manner.
Go ahead.
Well, counsel, what are the limits to this argument? I recently shopped at a Costco. Costco has its Kirkland brand, and that brand, its own brand, sells more in Costco stores than it's something like 30%. And that brand copies other more name brands, and they, believe me, they give it good shelf space. They do what they can to promote it under your rule, and Costco is developed and is the leading club store. Does that mean that their quote self-preferencing is illegal under your argument?
Well, Your Honor, I have 2 points in response to your question. First, it's that the difference between the Apple News platform and Costco is that Apple News holds itself out as an aggregated news source delivering to consumers news based on their preferences. And in that sense, consumers aren't expecting to have Apple product pushed to it ahead of other products in any way that's not based on the merits. So in this case, Costco consumers walk into Costco knowing it's a Costco store, maybe expecting to see the Costco brand more prominently than other stores. Here, Apple holds itself out, like Google in the Google search shopping case, as a forum that aggregates sources from other providers, and therefore self-preferencing is more of a problem here. Second, it's important to note.
So hold the second. You're saying therefore that there's an element, you might say, of consumer protection, of an element of the antitrust defense is deception of the consumer? I'm just asking to be clear.
Well, Your Honor, I think it is important to keep in mind that consumer welfare is the end game of antitrust analysis. But I think it's also important to note that what this self-preferencing does is it frustrates the primacy of consumer choice in deciding what are superior products in the market. Here, Apple has decided unilaterally.
It frustrates the primacy because the consumers are being tricked. Is that what you're saying?
Well, it's because the consumers aren't free to exercise their choice of what news they'd like to view on the platform. A digital platform is different from a physical store, wherein even if certain shelving positions is more favorable in a physical store, consumers have no problem seeing the vast array of products because it's finite. In the internet context, because the supply of news is essentially unlimited, when Apple presents a certain sect of news, consumers are much more beholden to the Apple's presentation because they'd be physically unable to survey the entire supply of news on the site because it is so voluminous. Unlike Costco, where a consumer would be free to look to other brands because they're right there on the shelf.
So if they wanted to see New York Times content, they'd have to just click over to that, right?
Well, Your Honor, the problem is that they have to affirmatively seek it out in a way that imposes burdens on the consumer, and they're more likely to simply default to the content presented to them. I think this is similar to the Microsoft case, wherein the DC Circuit in the United States found a problem with the inability to remove the Internet Explorer browser from Windows. It wasn't absolutely impossible in that case to use a competing internet browser on the Windows program, but the combination of the auto install of Internet Explorer and the difficulty of removing Internet Explorer made it practically difficult in a way that influenced the actual demand from consumers. In this case, there's no difference here because consumers would have to go well out of their way to find competing content.
Let me ask you this. You're saying that the 80-20 split on the front page, to take an example, right, really doesn't represent consumer preferences. Although it's represented that way. So let's say that in reality, if the algorithm followed consumer preferences loyally, Apple News would occupy, what, 40% instead of 80% of the front page, perhaps? Fair enough?
Well, Your Honor, we can't speculate to exact percentages, but the
something well
you're speculating to it.
Right?
Go on.
It must be something well under 80%, or otherwise your argument is trivial.
Well, Your Honor, it would be. I think we can look at the circumstantial evidence of the consistency there and determine that it would, at the very least, fluctuate as different news articles come out. In this case, it maintains consistency. And even if the algorithm was designed in a way that didn't arbitrarily uprank Apple products, it's still, in the fact that it's made in a black box and competing providers have no idea what criteria informs the algorithm, it's still designed in a way that only Apple could ever take advantage of this. This sort of objective.
Sounds like these data are a lot less essential than we thought, or than your colleague was arguing, or perhaps you were arguing, that the data are they're almost useless in terms of what Apple does with them.
Well, Your Honor, the data is essential to crafting objectively pro-competitive news that consumers desire, but without knowing how Apple funnels the data into the algorithm, it is true that competing providers can't craft their articles in a way that responds to the algorithm in a way that Apple can. But I'd like to move on to the second category of anti-competitive behavior in this case, that being the rules of behavior. The rules of behavior constitute two separate abuses of dominance. First, through the genre quota and the limitation on non-subscribers' access to legacy providers, Apple has implemented an arbitrary output restriction that is anti-competitive. And second, the rules of behavior constitute a margin squeeze intended to raise access cost on competing legacy providers, making it more difficult for them to operate on the platform. The output restriction at issue in this case is the arbitrary genre cap Apple imposed on legacy providers that doesn't likewise apply to A&N content. This genre cap has the effect of disconnecting supply from consumer demand and constitutes a naked output restriction. Naked output restrictions are illegal per se in the United States under Section 1 of the Sherman Act and are enumerated as anti-competitive behavior in the Treaty on the Functioning of the European Union, Articles 101 and 102. In this case, Apple has identified the most popular genres of news and set a cap on the amount of articles within that genre that legacy providers can write in a given period. This has the effect of disconnecting supply and demand. As the Supreme Court noted in the NCAA case, the fundamental problem with restrictions on output are that it doesn't correlate to consumer demand in what happens in the market. Here, Apple has actually identified the height of consumer demand and endeavored to limit the output. It's not only non-responsive to consumer demand, it's antithetical to it.
So let's take an analogous example. Let's say that Amazon has its own product in a particular batteries. Let's say they offer their own Amazon brand batteries or whatever brand they call it, and they say to a competing battery manufacturer, you can sell on our platform, but only 100,000 units a year. That would be a naked restriction on output.
Well, Your Honor, the problem here is that Apple has crafted these genre restrictions in a direct attack on what consumers want, and they only apply to legacy providers. So Apple, in this sense, identifies exactly where the highest area of demand will be.
So in my example, Amazon is saying if you want to sell more than that number of units, you can't do it on our platform. You can sell them wherever else.
Well, Your Honor,
and likewise, the New York Times can distribute its articles everywhere else.
Well, Your Honor, the problem in this case arises in Apple's market position. It is true that the New York Times isn't precluded from other means of distribution, but in this case, Apple, as a dominant firm, does have that special responsibility to refrain from certain conduct that would exclude competitors, because it is, as my co-counsel mentioned, a sort of gatekeeper for this marketplace here. By applying genre caps that only preclude legacy providers from publishing content and not A&N, all it's doing is determining that legacy providers can only meet, say, 30% of demand, and A&N will be free to fill in the balance. This can't have any sort of objective justification and necessity for the platform because the conditions don't apply equally to Apple providers and non-Apple providers. And similarly, the platform existed for 3 years without these genre caps. The fact that the genre caps were introduced in conjunction with the A&N platform is further evidence that they were meant to skew advertising revenue towards it.
So any changes? I'm sorry. Did you want to ask a?
No.
Okay. You're essentially saying that they have to justify to the courts of this jurisdiction any changes that they want to make?
Your Honor, I see that my time has expired. May I respond briefly?
Please do. Go ahead.
Well, Your Honor, in the case of a dominant firm, any change that doesn't provide a pro-competitive benefit to consumers, yes, must be justified if it has anti-competitive effects. In this case, the genre cap has no pro-competitive benefit to consumers. It's merely meant to cap the amount of demand competitors can capture. And in that sense, it's anti-competitive without a justification. In conclusion, the New York Times would ask that the court sanction Apple's anti-competitive behavior. Thank you.
Thank you, Mr. Fordice. Mr. Louvis, you understand you've reserved 2 minutes for rebuttal, and we will now hear from the respondents.
May it please the court. Chief Justice Ginsburg, Your Honors, my name is Justin Tennenbaum, and along with my co-counsel, Yeshesvini Chandar, we represent defendant Apple in the antitrust case. This is a case about the world's most innovative company, Apple, who has brought us the Mac, the iPod, the iPhone, the Apple Watch, among others, doing what they do best, revolutionizing technology. And now Apple is here again to defend its latest innovation, where Apple has redefined the way news is consumed. Now, the plaintiff has brought two claims here, a monopolization claim and a refusal to deal claim. My counsel and I will split the argument in the following way. First, I will address the monopolization claim, both the monopoly power element of it, and if the defendant is maintaining that power through anti-competitive conduct. And second, I will address the refusal to deal claim with the essential facilities doctrine as an exception. Finally, my co-counsel, Ms. Chandar, will hone in on Apple's pro-competitive conduct. Turning first to the monopolization claim, the plaintiff must show defendant has monopoly power. Without that monopoly power, there is no need to even look at the conduct. The court is in a great situation here. We have insight into the market share. If you look at the record on page 7, both parties have stipulated to the market share as the global online news content distribution, of which Apple holds a mere 42%. No US court has ever held a market share of 42% to equate to monopoly power. In US v. Alcoa, the court doubted whether 64% could ever be monopoly power, and the Supreme Court has never found monopoly power where a firm has market share under 75%.
Even in that very well, counsel, that's very good. But will you agree that with me that in Europe you're at the limit and arguably beyond it?
Yes, Your Honor. In Europe, the Commission has set the minimum, I believe, at 50% to show a presumption of dominance, but we are still only at 42% as of filing. Now, by market share alone, this case is not ripe for adjudication. Apple is 22% lower than Alcoa's doubtful claim, 33% lower than the Supreme Court. And
okay, that's good. That's good. But you began by telling us a number of instances where Apple has revolutionized the world, which is great, but where its strength, success, money, market share subsequently has become enormous. Now, do those technological triumphs that you are proud of help you in your case? Aren't they a basis for someone to say Apple is going to sweep the board in this field as in the other ones?
Your Honor, there is nothing wrong with having power as long as you are not abusing that power. And here, yes, the monopoly share or market share is lower than the threshold. So let's look to the barriers to entry, for instance. New York Times, the plaintiff here, has shown that the economies of scale are in favor. Apple has 100 million iPhone users, for instance. But what we're looking at here is a stipulated global news market. We are seeing modest growth in that market. Apple, year over year for the past 2 years, has only grown 2.5%. And again, the analyst expectations are in the range of 7 to 10%. And we know that analysts are wrong all the time. So we should be conscious of what facts we have here and what we are speculating on. But furthermore, the substitution of products is a big issue here. And there are so many substitutes to Apple's news platform here. The New York Times, to begin, is not some little player in the market. The New York Times has been in the news business for over 150 years and has won over 130 Pulitzer Prizes. It has a full newsroom. If anything, it would almost seem easier that the New York Times was able to establish a market online as opposed to Apple holding it out of this or foreclosing it from this market. Now, New York Times, we know already has an application you can download, and you can access their website by clicking www.newyorktimes.com into your search bar. So when the plaintiffs say here that Apple is acting as a gatekeeper, they're actually doing they're not acting as a gatekeeper at all. Competition in this sense really is one click away. Not to mention
Counsel, what are we to do here with the evidence of Mr. Cook? Aspen is it may be at the outer reaches of antitrust law, but that doesn't mean it's no longer the law.
Yes, and I will address Tim Cook's email. It was a heated email, but where there's smoke does not mean there's fire. So that email alone should not be dispositive of a monopolistic behavior or an essential facility.
You will agree that it's not a loan. There's a bunch of other things that should make your client squirm, surely.
Well, Your Honor, I believe that there is one stray email, and if we compare that to Novell v. Microsoft with Bill Gates's emails, that alone isn't enough. And then we have to look at conduct, which my co-counsel will really dive into. But along the lines of monopoly power, it's just not there. And if we want to break down Trinco or Aspen, we're looking at the outer bounds of antitrust law here. And just to distinguish from Aspen here, Aspen, the product market was 4 mountains. Here we have data. Data is an infinite product. It's consumed, it's aggregated, it's made daily. So when the plaintiffs use these analogies with a referee and players, that's entailing that there's a zero-sum game going on here, which just isn't the case. Not to mention the geographic market in Aspen, which was Aspen. Here again, it's a global market. There is nothing stopping New York Times or any other news provider from starting their own news service. In fact, as evidenced by that, the New York Times has already created New York Times 2.0 and is directly competing. And if the antitrust laws are for competition and consumer welfare, well, now what's happened is great for the economy. It's great for free markets because we now have a platform, Apple, competing against the New York Times platform. That's exactly what we want.
I don't think we have information in the record to tell us that the New York Times went ahead, that when they were terminated from getting your data and otherwise participating on the platform, they brought suit, but there's no indication that they launched their product, which is consistent with their claim that they cannot do so without access to your data.
I would have to check the record, Your Honor, but I believe they have already launched New York Times 2.0. Now, whether
assume with me that they have not, that they stopped in order to bring suit instead.
Yes, Your Honor. Then there's still a variety of other ways. Again, this is the New York Times. This is not some small news publisher. They have already an application. They have a website. They have the ability to track data. And if you don't think that they are not understanding their consumer trends as well, well, I mean, that's ridiculous. They're looking to appease consumers just as any other platform would. So where does it become Apple's prerogative to let them free ride off of this data so that they can then compete with them? Now, what's happening here, this is a contractual issue disguised in a trendy antitrust suit. The New York Times never sued for breach of contract, which they claim is one of the big issues here. And why? Because they know they violated the contract. And they know that they were violating it. They want the treble damages from the antitrust claim. And even if we went all the way to say that Apple was in the wrong here, which for various reasons they are not, who will set the price or terms of this data? Where's the remedy here? Is Apple?
You were selling the data already until you terminated them. I mean, you had priced it.
Yes. So is Apple just going to then give away all the data for free? Can Apple improve?
You missed my point. You have already priced the data. All you did was stop selling it to the New York Times. Correct? So you used to sell it to the Times at a known price. You sell it to others, perhaps at the same or a different price. Why wouldn't you just resume where you were if you're obliged to do so? Well,
to loop back around, we believe we have no duty to deal with a competitor.
I understand that, but you were putting another dog on the table when you say that there's a pricing problem here.
Well, let's play this out a little bit. If Apple were to then say improve their algorithm, right, would they be able to raise prices, or would that be against antitrust? There just isn't a workable remedy here. So.
Well, now the Apple continues, as I understand it, to sell its data, correct? It terminated only the New York Times, not the whole program of selling proprietary data.
That's correct, Your Honor.
Yeah, so it has a price. It knows what its price is. You have another point?
there's the point here is that there is a price, but if we develop the algorithm out, prices will change, and it would be an unstable market to put this kind of restriction on Apple to force them to deal. Not to mention, we don't believe that the essential facilities doctrine should even come into play here, as again, it's this notion of a pre-existing voluntary and profitable course of dealing is not what's happening here. First of all, in this market specifically, Apple's not a dominant firm. Second, there was a course of dealing for 2 years, yes. Was it voluntary? Yes. But then they breached a contract that they had agreed to on the terms and were booted from the platform. That was the remedy for the breach. Now, for them to show a willingness to forego short-term profits to achieve this anti-competitive end, we don't see any evidence of that. This New York Times platform for the first 2 years was unprofitable. And yes, it was bringing in revenues from the advertisements and from New York Times, but net revenue positive does not mean profit positive. We were actually operating in the red in profit. And so there's no single platform holding dominant power here. And although we're making revenue, we weren't making profit. We are just trying to operate strategically as a business would. To return to Tim Cook's email, which the plaintiffs are using a specific intent to forego profits, to show anti-competitive behavior. It's a heated email. He said some things that were competitive in nature. But again, we investigated these guys. They were cheating. They were violating the rules. And again, it's not why we're here. The question for this court is an antitrust question. So,
well, yes, but if the documents reveal that what you're defending as a legitimate business activity, in fact, was not only still having a question of effects, but if the intention was exclusionary, it certainly gives energy to the search for effect.
yes, Your Honor. And we don't see the emails as such. As quoted in the Novell case, this may suggest a hard-nosed intent to undo rivals, but does not suggest Microsoft intended to forego profits. And that's precisely what we feel is happening here. Tim Cook was upset. He was concerned about the viability and the threatening nature of what the New York Times was doing, and he acted in response to that.
Well, you can say that, but I'm reminded of a celebrated call by your former president to a person in Georgia, where Mr. Cook writes, "Go ahead and make my day, just give me a reason to get these punks and get the data out of their hands. Just give me a reason," suggests that it could be a fictitious reason. No?
Your Honor, I do sympathize with that. I believe that, again, that email specifically was in reference to an already alleged abuse. That's why I believe in that same paragraph, it says something to the lines of they were inquiring what the New York Times had done. At the end of the day, they found out that they were in violation of this contract. So this could act as some evidence, but we have to look at the end and play the tape out. What happened was they violated their terms and they were kicked off the platform. And this is just a hot-headed CEO that is competitive. And this is in the nature of competition, in the nature of consumer welfare, not in the nature of crushing competitors just to destroy them. I see my time has concluded. May I briefly summarize?
Well, you could give us one sentence, Mr. Tennenbaum.
For the reasons stated above, we believe that Apple has done nothing wrong here, and this court should dismiss both complaints. Thank you, Your Honors.
Thank you, Mr. Tennenbaum. We'll hear from Ms. Chandar.
Chief Justice Ginsburg, Your Honorable Judges, may it please the court. My name is Yeshesvini Chandar, and I represent defendant Apple Inc. For a plaintiff to show antitrust violation, they must satisfy three elements. The first, that the defendant had market power. Second, they must show that defendant's conduct led to anti-competitive harms. And third, that these anti-competitive harms are not outweighed by pro-competitive justifications for this conduct. My co-counsel, Mr. Tennenbaum, just focused on why Apple does not have market power. And I will focus on why Apple's conduct did not lead to anti-competitive harms. Before I proceed, Your Honors, I must address three issues that the plaintiffs bring forth that are critical to our analysis here. First, plaintiffs make the analogy to the referee and the jockey, but the sports analogy doesn't work here. It is not a zero-sum game. This is a platform where everybody wins. And henceforth, Your Honor's analogy of the Costco store is the better analogy to make, where if Costco is vertically integrating as a platform, if Apple is vertically integrating as a platform provider, that is presumptively beneficial, because what it does is it sharpens competition and forces rivals to sharpen up their and compete on the merits, while it is overall beneficial for the end consumer who loves Kirkland products and who loves a better price for a better quality product. So if New York Times is claiming that they want to compete on equal footing, that's precisely what Apple is provided here through its extremely customizable and extremely focused on creating a breakthrough customer experience news platform. It is providing New York Times an access to the 900 million eyeballs across the globe, while forcing New York Times to compete on an equal footing with Times of India from India and the China Daily from China. Second, plaintiffs confuse the consumer choice standard with the consumer welfare standard. And as your Chief Justice has written in a paper with the leading antitrust scholar, Joshua Wright, the consumer choice standard is not necessarily beneficial. And while it might be a revolution in antitrust law, it's detrimental to the consumers in the long run. And it is the defense's position that Masonia is a new country in the policy interest of being a new country in the digital economy, where innovation is the thrust for growth, the consumer welfare standard that focuses on innovation, investment, and efficiencies and fosters innovation is the better standard to adopt. Third, the plaintiffs complain about Apple having economy of scope in the data that they collect. And the fact that this scale gives Apple an advantage and the ability to almost pay nothing for this data. However, they are wrong, Your Honor, and they're wrong because, especially for data, scale is not a good thing. More data does not mean better. It doesn't make the data better. In fact, the best analogy I can make is to the Google Flu product. Google had all this data, but just because data has scale doesn't make it better. It's the algorithms and the quality of the predictions that you can fine tune that makes data useful and worthwhile. So just like Google Flu failed, there is no guarantee that Apple, with its huge amassing of data, is going to have a better product. But instead, it is actually, like Your Honors pointed out, it's not necessarily Apple that's going to sweep the floor based on its technology, but instead New York Times.
Let me ask a question about data.
Yes,
I mean, there are not perpetual increasing returns to data. It's not a natural monopoly, but even Amazon's chief economist wrote a paper where his point was that there are not increasing returns forever, but it's normal in the sense where there are increasing returns for a while. Are you arguing with that? It sounds like you're saying that we could have 100 efficient companies here.
Your Honor, I am not arguing with that because, in fact, it is the rules of con behavior that Apple has imposed, including restrictions on the content restrictions and the genre restrictions, are in fact, and the restrictions from hyperlinking away from the platform, are in fact in order to make this data set more valuable by continuing to track users' preferences on the platform and to sort of make sure that during this limited time span and attention span that users have for news, they stay on the platform and they continue to give us what they want and they continue to indicate what they like. However, I I still would, defendant still maintains the position that just because they have the scale of data doesn't make them better equipped. But in fact, it is New York Times as the expert in the news business, as the heavyweight who's been around for more than 100 years. And in quoting the IMS case, it is New York Times' ability to leverage on its, position in the news market that does not make Apple's data indispensable. And in fact, here, adopting the essential facility doctrine here, which has been quoted as being an epithet in search of limiting principles, would be perverse in this context for this particular record, because Apple is the new entrant. It's the upstart in the news business. What Apple is doing is what Apple does best. They do holistic innovation. They innovated with the product. They did product innovation. So they started off being an aggregator for a news platform. And then they realized if they wanted to really create a breakthrough customer experience, they needed to go further than that. So they then started vertically integrated and started producing their own content based on their and filling in the gaps based on the user preferences that they could capture from the usage data. And then what Apple did, though, is it was still not making business viability. So Apple did what Steve Jobs has been pushing Apple to do all these years, is not just product innovation, but also innovate their business model. So they innovated their business model, turned the dials a bit, and they changed the rules of behavior. And even after doing that, after another 2 years, Apple was still not making profit. And so what you have here is a business, an innovative company who's a new entrant, who's focusing on innovation and competing vigorously on the merits and merely trying to survive. This is a far cry, Your Honors, from the abusive conduct that a dominant player in the market would be able to engage in. But instead, because New York Times is the heavyweight and established competitor, this is more indicative of a disgruntled competitor trying to free ride on Apple's sunk cost for technology and innovation. And we must consider, this court must consider today overall, the policy interests for Macedonia as a new country and wanting to adopt a legal framework that will foster innovation. That is the thrust for economies in the digital economy. And so because the US legal framework is based on objective tests that allow for easier line drawing, as well as focus on innovation, investment, and efficiency, the defendant maintains that this court should analyze this framework under the US framework, where the essential facility doctrine is.
Counsel, you mentioned Professor Arita's famous article, but that's not the view in Europe, is it?
No, Your Honor. That is not the view in Europe. And it's the defendant's position that it isn't the policy interest for Macedonia to adopt the US framework. However, even if we adopted even the most restrictive regime in the recently passed German law, defendant would still win today for the following 3 reasons. First, yes, the German law recognizes 40% as the threshold for market dominance. However, it is a rebuttable presumption. Number 2, the German law does encourage courts to consider access to markets and supply chains. And that's precisely what Apple is doing here. It's providing access to the 900 eyeballs for the New York Times to be able to compete on equal footing with the China Daily and the Times of India from India. Third, the framework for exploitative abuse that the German law recognizes, while it condemns exploitative abuse, it still does recognize that you only condemn an antitrust violation when there are no objective justifications for pro-competitive benefits. And here, all Apple is doing in innovating, competing vigorously on its merits, providing access, and sharpening its rivals to compete on a level play field. There is no anti-competitive harm here. There is no antitrust injury, but only pro-competitive benefits from Apple's.
Chandar, let me hold you up a moment. Forrester, can we hear from you?
Yeah, I find your suggestion that as a political matter, we should follow the United States.
Yes, sir.
Intriguing assertion. Now, Macedonia is quite small country, and it's a new democracy, and it's situated in an area of considerable tension. Now, I'd like to hear you address the question, is a European tradition, which traditionally has been more sympathetic, so it is said, to the competitor, as well as, of course, to the public interest, isn't it, can you tell me of a country in the world which has elected to follow the American style of approach as opposed to the European one? Or alternatively, can you tell me why the European, shall we say, social model of antitrust is unacceptable for this country?
Yes, Your Honor. I will respond to Your Honor's question by emphasizing why the US model is better and the European model does not serve Masonia's interests. And that is because Masonia is a new country in the digital economy where innovation is the thrust for growth. And because the US framework focuses on innovation and bad antitrust policy can strangle innovation, and the fact that the US regime offers ease of administrative ease, and most importantly, Your Honor, we have to consider here that the US framework in the past 30 years or more has allowed for unicorns and innovative companies, and it has propelled economic growth in the last 30 years, where the US has trumped economic growth in the EU. So for Masonia as a new country that is trying to compete in a digital economy, as well as if it's focused on growth, economic efficiencies and growth, the US standard is a better regime to adopt because it's not constrained or restrained by industrial policy that drives the European framework. It is not restrained by historical, social frame constructs that sort of drive the European policy. And henceforth, when it is in this sort of vacuum where it has the ability to free form and choose, the US framework, because it drives efficiencies, protects investment, and it promotes unicorns and innovative companies, and because it has been the higher performing economy for the past 30 plus years in comparison to the European economy overall, is the better framework for Masonia to adopt, Your Honor.
And the second part of the question, any country that has followed the US model?
Your Honor, I am not knowledgeable enough to sort of, come back to you with any other country that has followed the US model. However, I do know that it is a defendant's position that it is the US model that would be the best suited for both the facts and the record for this particular case, as well as in the best interests of Masonia. And Your Honor, the big point here and the essence for a lot of issues that were brought up both by the plaintiffs and by my co-counsel, the essence of the matter here is that this market is a highly volatile and dynamic market, both because of the nature of the news product itself, which has a low shelf life, as well as because there are no restrictions on users as well as the legacy providers on this platform. So there is multi-homing possible. Users can download the New York Times through multiple ways. They can read. There is no restrictions that Apple is imposing on New York Times being able to communicate with the end user, while on the other hand, the legacy providers are not locked in either. And so because there are no restrictions on switching out and multi-homing being possible, and because there are no lock-ins for legacy providers, this is a highly dynamic market. And the news product itself, which is known to be a fast-moving consumer good, if I may make this sort of, classification, is a volatile market. And so, Apple being the new entrant is the one that is forced to innovate. If Apple is adopting vertical integration on its platform, there is absolutely nothing wrong with that, because all Apple's doing is its platform design is innovation at its best. It's focused on the consumer's interest, and it's focused on maximizing the end user's utility in their use of the platform. Apple has curated this news product such that when I stand in front of this newsstand, I see the news that I like to read. And when you stand in front of the newsstand, you see the news that you like to read. And that is creating a breakthrough customer experience for a drab product like the news, where the user has limited attention span and limited time. So, Your Honors, for all the foregoing reasons, and for the policy interests that I've articulated today, defendant requests that this court rule in the favor of defendant and dismiss this claim. Thank you, Your Honors.
Thank you, Mr. Chandar. And we have some time reserved for rebuttal on behalf of the New York Times.
Thank you, Your Honor. A few quick points in rebuttal. First, the defendant made much ado about abstract market percentage thresholds, but that ignores the fact that market share is merely a proxy for market power. And here we have direct evidence of market power. Apple increased its pricing for subscription models 50% 2 years ago, and those prices have not come down despite the fact that they are above Apple's marginal cost. This is direct evidence of an ability to implement super competitive prices, and therefore, even with a market share of 42%, Apple undoubtedly has market power in this case.
Weren't they unprofitable at that point? I believe they were.
Well, Your Honor, it's important to distinguish between the Apple News platform and ANN, the content provider. We have no evidence that the Apple News platform was unprofitable. It was merely the ANN content provider that was unprofitable until the restrictive rules of behavior were implemented. And if it's necessary for there to be competitive restrictions in order for ANN, the content provider, to turn a profit, that simply means that ANN is not a viable product in the market and shouldn't be allowed to implement competitive restrictions to get there. Second, I'd like to touch on the fact that the defendant couldn't name another.
I don't think if it's not a viable product and they raise the price, it becomes even less viable and they should fail. I don't see how it harms anybody else.
Well, Your Honor, the price increase was on the Apple News platform, and Apple used that as a means of subsidizing the ANN product and by implementing rules of behavior that restricted output from legacy providers and ensured that more advertising revenues would be diverted from providers such as New York Times to ANN. And I'd like to point out the defendant didn't make any attempt to address our claims about the output restrictions. In conclusion, this court should look to the principles of both US and EU antitrust law and determine that Apple has behaved anti-competitively here. Thank you.
Thank you, Mr. Fordice. The case is submitted. The court will take a brief recess to deliberate, and we will reconvene here in 10 minutes or so. We are back, and as you can tell, we were away for a little bit longer than we anticipated and led you to anticipate, discussing the foregoing arguments. Before we announce our judgment, it's my pleasure to announce the award for the best brief, which of course was decided not by this bench, but by others. And that award goes to Team F from the Indiana University Moore School of Law. And congratulations to Team F. Like all the teams here today, they've argued the case several times and on both sides, but their brief was competed against all of the other briefs, and it's really a distinct honor for them. And we're very pleased to have had them competing here. And the award for the best oral advocate, and this was based on all of the rounds prior to the current round, goes to Rita Shah, also of the Indiana University Moore School of Law. A sweep for Indiana. Congratulations to the Hoosiers. It was a pleasure to have you in the competition. Hope you'll be back next year. We turn now to this morning's proceedings, and I will deliver the judgment of the court and then turn to my colleagues for some feedback to our oral advocates. Although it did take a formidable amount of time, we did reach a judgment, and it was in favor of, and I don't want to get anything wrong here, so I'm going to look at my papers. It was in favor of the team of Ezra, Louvis, and Nick Fordice. So congratulations, Mr. Louvis, Mr. Fordice. Where are you from?
We're from Georgetown.
From Georgetown. Well, that's great. Okay, I'm delighted that you participated in the competition. And for the runners-up in this overall event, let us know, where are you from?
We're from the Kline School of Law at Drexel University in
I'm sorry,
Philadelphia.
could you say it again?
The Kline School of Law at the Drexel University in
Oh,
Philadelphia.
Okay, in Philadelphia, right. Well, I think this is probably the first time your school has participated. Am I right about that? Good. Georgetown has participated several times. Indiana has participated before. So we're glad to have you. Hope you'll be back. A lot of the teams that have been in competing have been here 3, 4, 5 times. And you can see the value of participating in it. So, Judge Muris, could you share some thoughts with us about the proceedings?
Sure. I enjoyed this. First time I've ever done this virtually, and I certainly enjoyed the topic, which is one on which I know a lot. I'm working on the Costco example comes from I'm working on a paper on online marketplaces, which I hope will be out at least on SSRN sometime soon. Although soon in the academic world is not soon in the real world. There were several impressive things. One of the most impressive was our last speaker, when asked a question, she said she didn't know, and that's a skill. There are lots of people who are as old as Judge Ginsburg and I are who don't have that skill. And to have it at such a young age is truly impressive. And not only did you say you didn't know, then you pivoted to what you thought mattered. So I thought that was.
Tim, you're frozen. Can you hear me? Well, I don't know if we've lost him. Oh no, he's still online. Judge Forrester, can we hear from you?
I hope so. Yes. Well, I sat in Luxembourg, and there we have 24 official languages and one working language, which is French. So we see Spanish, Italian, English, Irish, Dutch, Greek lawyers appearing, and the style is very different. And one of the great... Shall I?
Yes, go ahead. We'll come back to Tim.
Okay, then. One of the enormous differences is how superior the Irish and the British advocates are in general. Can't generalize, and there's always exceptions, to everyone else. And it's fun. I mean, the judges enjoy robust argument. The other judges, except for the Brits and the Irish, are too polite, in my view, in putting questions. So the brutality with which you have been treated this afternoon would be regarded as abusive and vile, committed other than by a Scot, an English, or an Irish. So I was extremely impressed. I've done moot courts often, and I used to be a debater when I was at university, and I thought the quality of the four of you was very high. And it's a pity that the way life is, even though the margins are very small, very narrow, one side has to be picked. So I'd say to both sides, it was very close, and it was very enjoyable to listen. I echo very much a frankness to the bench in saying no or yes or I don't know. That really wins you support instead of a wriggle, which is a convoluted way of conveying the unpalatable truth. I'd say when you're pleading before a court, here there's a timekeeper and it's a rush, don't be afraid to pause and think and then say it better. And when it comes to rebuttal, I always prepared a bit of rebuttal before I sat down before I started, because what you want is to win the big picture, and you decorate your rebuttal of the big picture with a couple of things that show you've been awake. But these are trivial observations. I really enjoyed myself very much.
Judge Forrester, we will test that proposition by inviting you back as well for next year and scheduling it when you can make it, whenever that may be, because your contribution to the proceedings was just lovely. Tim, are you back with us?
I hope so.
Okay.
Can you hear me?
Yes, indeed.
Yeah, I must have done in the 11 months since this thing started, I must have done 1,000 of these, and this is the first time that's happened. So as I was starting to say, this was a hot bench, and I thought most of you I thought all of you in some circumstances, and most of you most of the time did a good job of pivoting from the questions to what you wanted to say while you were answering the questions. Now, we, and I in particular, did the problem that you'll get if you try to, doesn't happen as much in real life, but when you try to divide up topics, and the judge isn't interested in your division of labor and ask you about another topic. Obviously, since you've been arguing on all sides, you were perfectly capable of doing that. One thing that is a potential problem, and depending on who your judges are, there are a lot of slogans in this area, and I think you need to be careful about reliance on the slogans. Antitrust is full of slogans, and this is an area, particularly because of now, and I've been involved in antitrust since the mid 70s, and because it's so popular in the press now, it's easy to fall into the hot topics in the press. And one of the nice things that this set of facts sort of avoids is you have two big companies against each other. But again, I enjoyed all of you, and I wish you luck in your careers. And this is not the first time I've judged this competition, and I enjoy it. So thank you.
I've been hearing cases virtually using zoom.gov since March, and I have not found it to be a problem, and we haven't, unfortunately, until today, I haven't got any technical encounters, technical difficulties. But I must say, I don't think that I've had any better arguments presented, or any more balanced arguments, uniformly well presented in those last 11 months than I heard today. It is surprising, I think, but true, that where I sit, DC Circuit Court of Appeals, it is by no means uniform that there is good advocacy on both sides of a case. If we hear 3 cases in a day, in a morning, and one of them has really good advocates on both sides, we are pleased. If it happens with 2, then we figure we're going to suffer under the law of averages, and the next week is going to be horrible. So you're at the top of in the top rank, and if you pursue appellate advocacy, as I hope you will, I hope you're considering it anyway, within the profession, I think you will be very successful, all of you. I am most frequently asked when I do moot courts by students, how important is it after all, how is the oral argument? And I think precisely because it's so interactive in the way that Judge Forrester described, it can be very valuable. We're not just listening to speeches. We are probing the soft areas of an argument, asking how far it carries, what the implications are. I think Judge Muris did that expressly in one instance. So in my experience, the judges come to this is a crucible of a moment. The judges have prepared, the lawyers have prepared, they all come together for this moment of high energy and intensity. And I would say that all of typically the judges come, if oral argument is worth having, it's because there are things that could affect the outcome. There are open questions in the judges' minds. Otherwise, we don't schedule oral argument. And probably half the cases that come to our court are resolved without oral argument. In some circuits, it's a much higher percentage. So you know that if it's calendared for argument, there's something that the court's interested in. Typically, I think what that is the judges come to the oral argument with a hypothesis or a preliminary view of how the case should come out. And the purpose for which they're using oral argument is to answer any lingering doubts that might affect that, clarify what they understand one of their or another of the arguments is, and often see if we can extract a concession that narrows the scope of the dispute so that the court isn't deciding anything more than is really necessary. That happens with some frequency because of the intense interaction. I see Judge Forrester concurring on that. So that's an important function for oral argument. Now, sometimes there can be a huge surprise. I've been on the court for 34 years and some months, and the biggest surprise I ever encountered came early in that period. There was a panel of our court that issued an opinion for the panel based upon a precedent of the court that they thought should be re-examined, and more than hinted as much in the opinion. And of course, there was a request for rehearing by the full court, and that was granted. And this was a case involving General Motors and the Environmental Protection Agency. There was no small matter, and there were no small counsel. It came out before the court en banc that the plaintiffs, General Motors, did not have standing. And that came out through the give and take, bringing different perspectives, 9 judges, asking questions that probed and revealed that there was no case legitimately in front of us. That is a once in a career event, I think, I hope. But plenty of surprises can come out of lesser magnitude, but something that really sets the court back on its heels saying, well, wait a minute, I thought such and such. Are you saying where is that in the record? Show it to me. I didn't see that. I want to go into that. I've sat in an English court where practice was quite different. I don't know, Ian, how this accords with your experience. It was in the High Court in London. And the judges began with expressions of sincere gratitude. Now, this is about 20 years ago, for the parties having filed an outline of their arguments with some citations in lieu of a brief at 4 p.m. the previous day. This briefing that we do was not the tradition. And when the argument began, if the judge wanted to talk about a particular case or counsel mentioned something and the judge wanted to follow up on, they called for the books and opened the books and started reading and discussing the case. So this is not atypical, I can tell from what Judge Forrester has indicated.
That's right. It's no longer really the practice, but it was expected that counsel who was opening would take the court through the case and the authorities, good and bad. And it was the duty of the counsel who spoke first to say, you must read that. It appears to be against us, but in fact, and similarly, the argument would go on until they were satisfied. And so my first appearance before the House of Lords, I got up on Tuesday afternoon, and I wasn't allowed to sit down until Thursday lunch. And that is a horrifying experience because, well, they're merciless. They hunted packs, and they lure you to the edge of the precipice, and they say, well, now, Mr. Forrester, you'd agree with me, wouldn't you? And you know that he's well, as you say it, my lord, the answer could well be yes, but it's natural. And you agree, and then you see that there's a great slippery staircase leading down to perdition, and you clutch at the banister and try to stop yourself and try to climb back up again. So you're not, the judges are certainly not hearing lectures. Actually, at that level, you are a privileged participant in a seminar as to what policy the court ought to follow. And it's hugely, it's a very privileged thing. And you're expected to keep arguing, and you're expected to state fairly the case against you. And you're expected not to weep as they are miserable to you.
Well, that's more of a burden than we place on opening counsel here. And in the case that I attended in the High Court and sat on the bench with the judges, I left at lunch, having spent the whole morning. But it was a case of a first impression involving the liability of a lawyer who had drafted a will and expressed the intent of the testator to bequeath his assets to his children, and then later on in the will, suggesting that they were A and B and having forgotten about C. And C was indeed cut out of the will as a result and was bringing the case against the barrister and the barrister's insurance company, if there was one. So this had never been resolved on appeal before. In any event, although we've taken our tradition from our British forebears, we've cut it down to the point that even in our Supreme Court, it's 30 minutes per side, and the guillotine falls after 30 minutes. When I was clerking there for Justice Marshall, I heard an argument. One of the problems in the Supreme Court is a lot of the lawyers, was much more true then, are never going to be back in the Supreme Court. And so they've got this case and they're not going to give it up. And so it was with the Attorney General of Arkansas, who really should not have argued that case. But now, of course, we have the emergence of a not specialized, but at least not a specially certificated bar, but a bar that specializes in Supreme Court advocacy. The worst one was an assistant attorney general from New York State in a welfare case who began her argument, and after 5 minutes or less of reading it, then Associate Justice Rehnquist said, "Counsel, are you familiar with Rule 44 of this court?" Which, of course, she could not be. And said to no, Your Honor. And he said, "Well, it provides that arguments that are read are not favored." Well, now, of course, she was completely up a tree because she hadn't really prepared to deliver an argument of the sort that you all just delivered. Anyway. So how important is it? Well, the judges, as I say, come in with these uncertainties. They get them resolved. I would say that 80 to 90% of the time they're resolved as the judges had expected, which usually leads to a unanimous panel, not always. And in that 10 or 15%, or maybe it's a little more, something changes, and in maybe 10% or 5%, the outcome changes. But it's more frequent that an issue gets discarded, or sometimes I might say avoided, or that the judges themselves find a way after argument to narrow what they're actually going to decide.
Yes.
Because they've been found that they could do so based on arguments, on the concessions and so on. So it's very valuable. And that's why the best advocates get well rewarded for their time. You may know that Chief Justice Roberts, when he was in private practice, and he had a lot of cases before the Supreme Court, I don't know if you know this, told me, and I think he's told others, he left home 2 weeks before argument and checked into a hotel and did nothing else. Didn't go to his office and didn't go home for 2 weeks. And I can imagine that that makes a lot of sense as a way of preparing for it. Before appearing before the House of Lords, Ian, I think I would just absent myself perhaps forever. Not show up. Before we close, is there any questions? I mean, this is your opportunity if you have a question or two, or a comment for that matter. They're also articulate and unembarrassed, but
Is there one thing we could each do better for the next time as like a learning experience for us with that?
Well, it's hard, I'm hard pressed to say, because I think for one thing, everybody's command of the record was complete. Now the record in some cases is much longer. In Microsoft, the record was 70,000 pages. The company graciously digitized it for us, well, for everybody, government and us. But in those days, the graphical exhibits could not be digitized, so we had hundreds of graphical exhibits. Anyway, your command of the record was stellar, and that is always a challenge. I mean, it's extremely important. You don't want to get caught flat-footed with a question about some odd lacuna in the record, not lacuna, but some small matter in the record. So I would be just cautionary about that. No, I would not fault anybody here for how you performed. I think Mr. Tennenbaum got started a little bit awkwardly or formally. I don't know if you had your first couple of sentences prepared or so on, which is not a bad practice. It's often remarked that in our Supreme Court, if a counsel goes for 2 or 3 sentences without interruption, he's dead. Court's not interested in what it's hearing. That was not a problem for anybody. But so it took a while to relax and get into the spirit of a conversation. The best argument I ever saw was Larry Tribe from Harvard Law School. It was in 1975 in the Supreme Court. And it was just as if these 9 people had come over to his living room to have a chat. He was handling them in that way. It was remarkable, something to see. So that's what you want to aspire to, a conversation in which you're getting a point across. I think maybe lastly, there's a wonderful book on appellate advocacy by Carl Llewellyn, who's writing in the 30s and 40s from Yale and Columbia, ultimately, I think briefly at Chicago. Anyway, it's called The Common Law Tradition, Deciding Appeals. And in talking about writing a brief, but I think it's just as true with oral argument, and I think one of my colleagues suggested as much. He talked about putting into the brief what he called an opinion kernel, the thing you want the court to repeat back in its opinion. And if it's well honed, it's very tempting for the court to pick it up and use it. And he gives examples of where that happened. But similarly with oral argument, I think what you were saying, Judge Forrester, about rebuttal, you want to leave the court with your version of the world in some way that's very memorable and I think maybe graphic or visual, something that people will understand and be the last thing they're going to hear.
I would, yes to all of that. I would say you cannot be too simple. And good advocacy involves mastering, getting the great lump of heterogeneous, floppy facts which aren't coherent, and then combing it and combing it and combing it until you've got 5 or 4 simple propositions. And it may take days, months before you realize what those 4 propositions are. And I used to do an exercise with my colleagues. Tell me your story. You've got 20 minutes. Thank you. Tell me your story. You've got 10 minutes. Now tell me your story. You've got 5 minutes. Thank you. Now tell me your story, and you've again got 20 minutes. And the 20-minute version at the end was far better, focused on the essentials, less repetition, less divergence, much, much clearer and simpler. So that's one very, very strong observation.
That was worth the price of admission.
That was great.
And second, if you can find elegant, simple graphics, I don't like with slides because the slides are my rivals. I want people to look at me and follow my logic, but sometimes slides are nice. In the Microsoft case, my slides were done by the cartoonist of Bill Gates. And another training exercise, I was to meet this gentleman whose first 2 names are Ian Stewart, same as me. He was Ian Stewart Grant. And tell me what this case is about. So I told him what the case was about. And he had a pad. And he was, as if he was a courtroom artist or something. And I guessed he was taking notes to give me feedback. And so I finished my spiel describing the facts. And then he showed me his pad. And this was a diagram of how Microsoft's server networks communicated with each other. And I said, yeah, that's correct. But the file and print doesn't go that way. It goes through this server here. He said, that's not what I heard. Tell me again. And so to the mere artist who was drawing the cartoons, the diagrams, I went through it again for 40 minutes. And then he drew me as he listened, he drew the diagram. And this time the diagram was perfectly accurate. So checking yourself into the hotel for 2 weeks, or my habit was to get up at 5 a.m. Before the argument. And mysteriously, what I'd planned for weeks to say always changed between 5 a.m. and 8 a.m. Always. Now, that said, I end up by warning you that I have an exceptional distinction. I think I still am the holder of the title of the world's most unsuccessful antitrust lawyer, since no lawyer in human history has ever seen their clients fined as much as mine. I hit the €3 billion mark first. So it's not mentioned yet in the Guinness Book of World Records, but I'm sure it will be written up in due course.
I hope there's no negative contingency for that. My colleagues have been most generous with their time. I think we're about to lose our lease on this courtroom.
Right.
But I will say, don't expect to be able to show slides in our courts of appeals. Was it in the Court of Appeals, Ian, that you did that?
Yes.
Yeah, we don't allow exhibits, and by special request, sometimes we'll get a request to put an easel up with some one page of graphic on it. It inevitably comes from a trial lawyer. If we grant it, we pretty much find it worthless and a distraction from the argument. So I would not pursue that in an American court anyway. Well, until next year when we reconvene, the court will adjourn. This term is over. Congratulations to all of you. You have a good deal to brag about, all of you.
Yes.
Thank you. And
Thank you.
we'll take our leave. Thanks for participating, all of you.
That was good fun. Thank you.
Really.
Thank you all so much.
Thank you.
Thank you.
Really enjoyed it.